and welcome to this recorded webinar on REM, the latest Court of Appeal decision on the use of intermediaries. I'm Rachel Chan, and I'm joined by Gemma Farrington KC.
Hello.
And together we appeared for the child through their guardian, instructed by Emily Carter-Birch of Child Law Partnership. A case note and a link to all the case law, practice notes and guidance, as well as the submissions made on behalf of the FLBA, as well as the recording of the hearing itself, are available on our website. If you have any questions during the course of the conversation, please send them through to events@42BR and we will get back to you as soon as we can. So first, what we're going to do is Gemma will be taking you through the case law up until REM. I'm going to be looking at the various practice notes and practice guidances before having a general discussion about the case itself. And then I'll be taking practitioners through a quick guide or a number of tips when looking at making your application for an intermediary. So Gemma,
Thank you.
the case law.
Thank you, Rachel. So I'm going to start by going through some of the case law, and just to say that I had a look back at a seminar that I did back in 2022 and noted that within that seminar, which was on using intermediaries in care proceedings, the same case law has effectively been referred to and confirmed in the latest Court of Appeal case of REM, as have the provisions that govern the appointment of intermediaries within care proceedings. So just looking at what those what cases are and what those provisions are. First of all, we start with Part 3A and Practice Direction 3AA for Family Procedure Rules 2010, which Rachel has already said are going to be on links, which you can get via this webinar. And the case law that was being referred to back in 2022 was RES Vulnerable Parent Intermediary 2020 EWCA Civ 763. Another case with S Vulnerable Party, Fairness of Proceedings 2022 EWCA Civ 8, and a slightly older case, the N, a child, 2019 EWCA Civ 1997. Now, also back in 2022, I did the seminar with Alison Pryor, who's a member of these chambers, as well as an intermediary called Diane Robson, who's an intermediary from Triangle. And one of the areas that Alison covered was how intermediaries have been used within the criminal jurisdiction, and she focused within her seminar piece on Crown and Cox. We'll come later to some recent High Court cases, but it's interesting that the criminal provisions that Alison was looking at were effectively taken up by the High Court in recent cases, which has somewhat diverted the application away from whether it is necessary or not to have an intermediary. But as I say, we're going to look at that a bit later on. So looking at REM, certainly Lord Justice Peter Jackson confirmed that Part 3A and Practice Direction 3AA were the starting point for any application to consider whether an intermediary was necessary. And he also looked at the cases that I referred to, which were being referred to back in 2022. And in particular, at paragraph 34 of REM, he sets out about RES Vulnerable Parent Intermediary 2020 EWCA Civ 763, and notes that it concerned the refusal of an intermediary assessment for a mother with a learning disability at an upcoming final hearing that was due to take place in hybrid form. The judge had accepted that she was a vulnerable party and had made other participation directions. In allowing the appeal, Lord Justice Peter Jackson summarised the effect of Part 3A and the practice direction and observed at paragraph 26 of that case that it is central to my consideration of this appeal that there is to be a hybrid hearing in this case. The hearing will involve quite complex information being considered through more than one medium of communication. Professionals who are having to adapt to these demands have the advantage of repeated exposure to a range of possible formats. Lay parties do not generally have that advantage, but it is to their needs that the court must adapt. Where a party or a witness has a learning disability, the adaptation needs to be sufficient to ensure that they are genuinely able to participate effectively in the hearing, both in and out of the witness box. And he concluded that the judge's decision might have been sustainable ahead of a conventional face-to-face hearing, but that she had not sufficiently addressed the additional factors to which a hybrid hearing would give rise. And he said back in Ries, it was, I think, necessary to step back from the detail of the rules and look carefully at the likely experience of this vulnerable parent attending a hearing in what is for her a complex format with the prospect of the removal of her baby hanging over her. And finally, paragraph 32 of Ries, Lord Justice Peter Jackson said, I would end by emphasising that the outcome of this appeal does not imply that all parties or witnesses with a similar profile to this mother will require an intermediary, or that intermediaries are likely to be required in all cases where a parent with a learning difficulty may be taking part in a remote or hybrid hearing. All decisions of this kind are case-specific and must be reached by applying the rules and guidance of the actual circumstances of the individual case. He also, within Riem, had a look at Rien, which was a case that was decided by Lady Justice King, and it was a case where the evidence given by the mother at a fact-finding hearing caused the judge to be concerned about her cognitive functioning. She nevertheless made findings of fact and gave directions for the welfare hearing. These included a psychological assessment, which led to an intermediary assessment and a recommendation for an intermediary. That precipitated an application for the reopening of the fact-finding hearing, which the judge refused. In allowing the appeal, Lady Justice King reviewed the history leading to the 2017 amendments to the Family Procedures Rules. She summarised the new provisions, which she described in paragraph 48 of that judgment, as sitting side by side with Article 6 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. And she concluded that, in my judgment, Part 3A and its accompanying practice direction provide a specific structure designed to give effective access to the court and to ensure a fair trial for those people who fall into the category of vulnerable witness. The wholesale failure to apply the Part 3 procedure to a vulnerable witness must, in my mind, make it highly likely that the resulting trial will be judged to have been unfair. And then Lord Justice Peter Jackson also had a look at Ries, the Vulnerable Party Fairness of Proceedings, which was a decision by Lord Justice Baker. And it was an appeal arising from findings of fact in care proceedings about children in one family which were adverse to a parent of other children who had given evidence as a witness. Subsequently, proceedings were taken in respect of her children. She was assessed as requiring an intermediary in the second set of proceedings, and she appealed against the findings of fact in the first set of proceedings, advancing fresh evidence in the form of the cognitive and intermediary assessments. Lord Justice Baker reviewed the provisions of Part 3A and the practice direction, and he referred to Lady Justice King's concluding remarks in Rien, and also added, it does not follow, however, that a failure to comply with these provisions, whether through oversight or inadvertence, will invariably lead to a successful appeal. The question on appeal in each case will be first, whether there has been a serious procedural or other irregularity, and secondly, if so, whether the result of the decision was unjust. Now, Lord Justice Peter Jackson within Rien commented that considering that the regulatory framework is recent, that is Part 3A, it is unpromising ground for a wider exercise in judicial interpretation. But he goes on at paragraph 37 in Riem to say that is, however, what happened in West Northamptonshire Council and KA Intermediaries 2024 EWHC 79 FAN. And in terms of looking at West Northamptonshire Council and KA, it's worth noting that, in fact, within that case, which is a case by Mrs. Justice Leven, she gave guidance on the issue of the appointment of intermediaries within care proceedings, particularly vulnerable parties, but in a case where, in fact, there was no real issue for her to determine. And it is noted within Rien that, accordingly, council had not been invited, or there had not been the opportunity for them to provide submissions in respect of that particular issue. In any event, Mrs. Justice Leven looked at the case of Crown and Thomas from the criminal jurisdiction, and she set out at paragraph 14 of the West Northamptonshire case the following, which she said were principles that can be extracted from this passage. And she said at 45A, it will be exceptionally rare for an order for an intermediary to be appointed for a whole trial. Intermediaries are not to be appointed on a just-in-case basis. And she refers to Thomas, paragraph 36. This is notable, she went on, because in the family justice system, it appears to be common for intermediaries to be appointed for the whole trial. However, it is clear from this passage that a judge appointing an intermediary should consider very carefully whether a whole trial order is justified and not make such an order simply because they're asked to do so. Then at B, she set out that the judge must give careful consideration not merely to the circumstances of the individual, but also to the facts and issues in the case, and refers to Thomas, paragraph 36. At C, intermediaries should only be appointed if there are compelling reasons to do so, and she refers to Canon Thomas at paragraph 37. An intermediary should not be appointed simply because the process would be improved, and she refers to Crown and Cox. Then at D, in determining whether to appoint an intermediary, the judge must have regard to whether there are other adaptations which will sufficiently meet the need to ensure that the defendant can effectively participate in the trial. She refers again to Thomas. And then at E, the application must be considered carefully and with sensitivity, but the recommendation by an expert for an intermediary is not determinative. The decision is always one for the judge, and she refers to Thomas in paragraph 38. And then at F, if every effort has been made to identify an intermediary but none has been found, it would be unusual. Indeed, it's suggested very unusual for a case to be adjourned because of the lack of an intermediary, and she refers to Cox at paragraph 30. And then at G, at paragraph 21 in Cox, the Court of Appeal set out some steps that can be taken to assist the individual to ensure effective participation where no intermediary is appointed. These include having breaks in the evidence and, importantly, ensuring that evidence is adduced in very shortly phrased questions and witnesses are asked to give their answers in short sentences. And this was emphasised by the Court of Appeal in Crown and Rashid. Lord Justice Peter Jackson dealt with this at paragraph 40 in Riem, and he really comes straight to the point. And he says, I do not consider the decision in Thomas to be an aid to the interpretation of Part 3A of the Family Procedurals. Part 3A was the product of the Vulnerable Witness and Children Working Group, whose final report in February 2015 heralded a greater awareness of the needs of vulnerable persons in family proceedings. The guidance in Thomas drew on the 2015 Criminal Practice Direction, which provided at 3F.13 that directions to appoint an intermediary for defendant's evidence will be rare and for the entire trial extremely rare. But he notes that these references did not appear in the Criminal Procedure Rules 2020, nor in the current 2023 Criminal Practice Direction, which addresses intermediaries at 6.2. Well, on the back of West Northamptonshire, practitioners will be aware that there was then two other cases that came from Mr. Justice Williams. And the first of those is Re X and Y Intermediary Practice and Procedure 2024 EWCA 906 FAM. And this was a case where Mr. Justice Williams adjourned an application for an intermediary assessment. And within the judgment, he reserved the question of whether it encompassed, that is, having an intermediary, an application for an intermediary encompassed assisting a party during a hearing to understand the evidence given by others, or assisting a party to read papers and to give instructions. Well, in fact, within the Court of Appeal judgment, Lord Justice Peter Jackson does consider that, and that's in the second part of paragraph 25. And he sets out there that a party's participation in proceedings includes giving instructions and making written statements, a process that requires questions and answers. The witness statement of a witness called to give oral evidence will stand as their evidence in chief unless the court directs otherwise, and that's Family Procedure Rule 22.6 in brackets 2. Under Family Procedure Rule 3A.5, the court must consider whether the quality of evidence given by a party or witness is likely to be diminished by reason of vulnerability. This cannot sensibly be limited to oral evidence. There may therefore be circumstances in which an order for intermediary assistance will be sought for a legal conference away from court, but this will call for a separate exercise of judgment. So, in effect, we have an extension there of where an intermediary can be used. It will be a separate application and it will need to be considered in a separate way by the judge, but it's clearly very useful clarification for practitioners in this area. In terms of going back to Re X and Y and the judgment of Mr. Justice Williams, he also referred within that judgment to phrases such as very rare or rare cases. And Lord Justice Peter Jackson said that they are not a substitute for a straightforward application of the rules. So then finally looking at Oxfordshire County Council and Mother and Others, intermediary appointment refused 2024 EWFC 161, which, as I say, was another decision by Mr. Justice Williams. The Court of Appeal had a look at the rationale within that judgment. And one of the matters that Lord Justice Peter Jackson agrees with, and this is at paragraph 46, is that it will usually be critical that an intermediary is provided with an expert report which addresses the cognitive abilities of the party and any issues which bear upon their vulnerability. So ordinarily that would be a cognitive assessment by a psychologist or a psychological report. He goes on to consider how Mr. Justice Williams dealt with the application within that case, and in fact finds that the conclusion that was reached by Mr. Justice Williams was one that he came to it by applying what he termed the unvarnished test of necessity. So that's where we've ended up back again, apart from the small diversion with West Northamptonshire and X and Y, we've come back to that the test is straightforwardly one of necessity. So now I'm going to hand over to Rachel. He's going to go through the practice directions and local practice direction, which were also considered by the Court of Appeal.
Yes, so the first one is the local practice note. It was adhering to the public law outline in London issued on the 28th of November 2024 by Mr. Justice MacDonald. And the relevant paragraphs are paragraphs 36, controlling the use of intermediaries, and paragraph 37. So intermediaries should only be appointed by the court where there is a compelling reason to do so, and not simply because the process will be improved or made easier. It will be exceptionally rare for the court to appoint an intermediary for the whole final hearing. It is not appropriate for intermediaries to be appointed just in case they may be required. Paragraph 37 says, in deciding whether to appoint an intermediary, the court will have regard to the facts and issues in the case, including factual complexity, legal and procedural difficulty and length, and to whether there are other adaptations that will permit effective participation without the need for an intermediary. All advocates should be familiar with the Advocates Gateway and the advice on how to help vulnerable parties and witnesses understand and participate in proceedings. An expert recommendation for an intermediary is not determinative. It will be unusual for the case to be adjourned for a lack of an intermediary. The next significant practice guidance came from the President in his practice guidance dated the 23rd of January 2025, labelled the use of intermediaries, lay advocates and cognitive assessments in the family court. And the relevant paragraphs dealing with intermediaries are paragraph 10, where it says FPR Part 3A addresses two distinct issues: whether a party's ability to participate in proceedings is diminished by vulnerability, and or whether a party's or witness ability to give evidence is diminished by vulnerability. It should be noted that one may exist without the other, or both may be present, as is clear from the case law, and he referred specifically to the case of West Northamptonshire and the two Mr. Justice Williams decisions in X and Y and Oxford County Council in paragraph 8. It will be rare, even where an intermediary is necessary for the giving of evidence, for them to be required for the entirety of the hearing. Consideration should be given to alternative measures to enable participation in the hearing. Paragraph 12. Vulnerability covers a wide spectrum. Only towards the far end of the spectrum will there be cases where an intermediary is necessary for the giving of evidence. Only at the very far end of the spectrum will there be cases when intermediary is required for the whole of the hearing. and only in the very rarest of cases will an intermediary be necessary to enable the party to give instructions in advance of a hearing or be required for conferences. Re-M, the court deals with both of those, the practice note and the practice guidance, and specifically the court refers to the reservations that they had. Paragraph 44, these projections, including references to very rare or rare cases, are not a substitute for a straightforward application of the rules. The next guidance we have is the Family Justice Council guidance on neurodiversity that was issued on the 30th of January 2025. And it should be noted that the president of the Family Division is also the chair of the Family Justice Council. Page 15 refers to the case of West Northamptonshire Council, and page 16 says at the very end, whilst all parties aided by the opinion of an expert may support the appointment of an intermediary because it will make the hearing potentially easier, that is not the test the court applies, and the judge has to consider whether the appointment is justified. So yet another word in substitute there for the test of necessity. So having taken you through the case law and the practice notes and the practice guidances, we're now going to talk about the case in general. And where does that leave us, Gemma?
Well, I think it's a really interesting case. I think the judge tried to, well, certainly was aware that the test was necessity because he set that out in his judgment. And then I think he was effectively, I'm going to use the word diverted away from that because of the recent High Court cases. So he was looking at concepts of rare, compelling reasons, and that took him away from the pathway of simply applying Part 3A in Practice Direction 3AA. And I think that's what the Court of Appeal, well, that's what they found. And in effect, they're saying it wasn't really his fault, that was, it was kind of, understandable that there was that sort of confusion or pressure, whatever you want to describe it as. I think also he failed to even engage with the ground rules hearing process. And I think that led him astray. I mean, what do you think about that, the ground rules process?
So he had given directions that on two previous occasions that he was going to look at ground rules at the review hearing, which was the hearing where he refused the intermediary. Having said that he was going to do that and directed that, he didn't then go on to consider any ground rules after refusing the use of an intermediary for the fact-finding hearing, and hadn't provided for any future consideration of ground rules, because knowing that the fact-finding hearing was then later adjourned, there was no provision for that to be further considered. But rather interestingly, within the judgment of the Court of Appeal, one of the things that swung it, if I can say, for the use of the intermediary was the judge hadn't considered the submissions of the other parties. And clearly there was evidence from the social worker, and there was evidence from the children's guardian. And
two children's guardians.
Two children's guardians, and the Court of Appeal deals with that at paragraph 73, subparagraph 3.
List there, isn't there? And if you look at paragraph 73, they set out a whole list there.
Yeah, the decision not to seek the views of the other parties was also unhelpful to the judge, as he would have found that each of them, for their own reasons, supported the mother's application. There had been two guardians. The first had filed an early analysis, noting that the mother struggled to verbally respond to basic greetings and simple questions about herself and her child without significant input and support from the grandmother, while the current guardian had grave concerns as to the mother's ability to manage in court without significant support. And then the grandmother, who was actually an intervener in the proceedings, who was in the pool. She was in the pool, and she was obviously facing proceedings herself, but found herself in the invidious position of having to support her daughter and deal with proceedings as an intervener in herself. So she also supported the application, as did the social worker, who also in her dealings with the mother had significant concerns about her ability to participate in proceedings.
And I think the court were also concerned that, you know, the gravity and the nature of the proceedings had not necessarily been taken into account, because there was many fact-finding here. If findings were made against the mother, it would not only affect her care of that child and whether that child could come back, but any other child that she had. So far-reaching decisions were going to be made, and she had had the benefit of an intermediary case management hearings, but then had that removed for the fact-finding hearing. And they also commented upon the fact that that really hadn't been set out as to why that decision had been made.
Absolutely, and I suppose it's having had the intermediary for those case management hearings and it being withdrawn at a time that
she needed it most.
Absolutely. And then there was an interesting comment by the Court of Appeal about the Mother's Counsel's ability to not only put questions in cross-examination, but also to support her client all the way through the hearing, would put her in an impossible situation.
And they also drew attention to that. In fact, the intermediary who had undertaken the assessment was actually there in court. So if the judge had had any concerns about it, he could have given a provisional view, invited submissions from the other parties, and also asked the intermediary to address him. And none of that was done. So I think it's a really important list that they set out at 73, paragraph 73, in terms of how these really important applications have to be dealt with in future. Because everybody is very aware that circuit judges, any judge, very busy, have very busy lists, probably going to have to make, as this judge did, many case management decisions. But what they're clearly saying, I think, is that you can't just deal with this in a quick fashion. It's got to be dealt with properly, and it's got to be properly considered. And the test is necessity, and there doesn't need to be a gloss on it. That is the
absolutely test. So that leads me very conveniently onto some tips for practitioners. And I think this case sets out very clearly a number of things that practitioners need to bear in mind when making an application for the use of an intermediary for their client. So first, paragraph 23 makes it very clear that intermediaries are not expert witnesses and are not appointed under Part 25 of the family procedure rules, because often you will see a C2 application applying for an intermediary as an expert witness. But this decision makes it very clear that the application should be made either in a document that originates the proceedings or by a later Part 18 application. The application must explain what measures are sought and why each of them would be likely to improve participation or the quality of evidence, which is a slight shift, change in what we're used to seeing as practitioners. So you need to make it very clear when making your application for an intermediary what it is that you want the intermediary for. And paragraph 24 sets out, if an intermediary assessment is granted, the recommendation is for intermediary assistance. It should again be made clear what actual order is being sought. In particular, there should be clarity about what hearings or parts of hearings an intermediary would attend, and whether it is suggested that an intermediary is required for other legal meetings inside or outside the building. The provision of a draft order will assist.
I think that's really important, the provision of a draft order, because that's not something that practitioners have been doing when they've been making these applications, to my knowledge anyway.
Definitely not. But this also helps when looking at the application itself, what you need to be, what it is that you're asking for. Are you asking for an intermediary for legal conferences, or are you asking for the intermediary
just for evidence?
for just for evidence, just for throughout the hearing, case management hearings, and of course within the judgment, the body of the judgment, it does deal with the fact that conferences in a solicitor's office will have less pressure than the court environment.
May not be necessary to have an intermediary in a different situation.
Yes, and it says breaking matters down in this way reduces the risk of unsound all or nothing orders being made. The court will no doubt seek to avoid making repetitive orders, but may give directions that last for certain hearings only and revisit and revise directions in the light of experience. Then turning to paragraph 26, which deals with evidence is needed. It says there will often be a cognitive assessment. And a tip here is when you're looking at instructing a psychologist to conduct a cognitive assessment, it will be useful for the letter of instruction to deal with these matters. If it recommends the use of an intermediary, it must evidence why that is necessary and explain why alternative means are inadequate. It would be helpful for the report to consider the parties' participation at case management hearings, legal conferences, and when giving evidence. And if the court then approves an intermediary assessment, the cognitive report should be supplied to the assessor. And that in itself is really important. And then paragraph 7, subparagraph 6, says that an application for an intermediary must have an evidential basis. I've dealt with the cognitive assessment. Other evidence may come from the social worker or the children's guardian. The court can also take account of submissions on behalf of the vulnerable person and from other parties, as they may have their own perspectives on the overall fairness of the proceedings. And this reflects the collaborative nature of the task of identifying and making adjustments for vulnerability. Whatever the evidence and submissions, it is for the court and not others to decide what is necessary to achieve a fair hearing in the individual case. And then dealing with submissions from other parties in greater detail, paragraph 27 says, the court is entitled to take into account of the parties' submissions to whatever extent it considers appropriate. So then once an intermediary is either granted or not granted, paragraph 7, subparagraph 8 makes it clear that the rules provide that the reasons for a decision to approve or refuse participation directions for a vulnerable person must be recorded in the order. That can be done very briefly, and it is a further useful discipline. And I think that's really, really important because from a practitioner's point of view, if you're picking up a case that someone else has done and it's not evident from the order why an intermediary was either granted or not, it can be quite tricky, can't it?
Can, I agree.
The court didn't deal with the issue of funding. Paragraph 29 said it wasn't that they didn't hear any submissions on the issue of funding, but it's clearly been established that HMCTS will pay for an intermediary within the court hearings, and a pro authority from the legal aid agency will need to be sought if you want an intermediary to assist you in conferences. So on that note, we've covered the case law. We've looked at the practice notes. We've looked at a practitioner's tips, as it were. So Gemma, tell me, what is your favourite paragraph in this judgment?
I think it's the paragraph that I've already referred to, which is where effectively Lord Justice Peter Jackson just says, I don't think that the decision in Thomas is an aid to the interpretation of Part 3A of the Family Procedure Rules, because I think that's where the little diversion was coming in, taking away from what's quite clearly set out in the rules that we've got within the family jurisdiction. So I liked that, and setting out why, looking at the background as to why he didn't think that was appropriate. What about you?
So I've got two, a bit greedy there. Paragraph 7, subparagraph 2. The test for the appointment of an intermediary for any aspect of proceedings is that it is necessary to achieve a fair hearing. Decisions are person-specific and task-specific, and the introduction of other tests upsets the balance struck by the FPR and may draw attention away from the circumstances of the individual case. And my other paragraph, my second paragraph, is paragraph 41. There is in any event no warrant for overlaying the test of necessity with concepts of rarity or exceptionality. Frequency is not a test, nor is exceptionality. Similarly, the introduction of tests of compelling reasons or of adjournments for lack of an intermediary being unusual or very unusual beckon the court to short-circuit its consideration of the evidence in the individual case. And I think the reasons why I like those two paragraphs is that it provides the clarity that us as practitioners have been seeking for a considerable period of time. And it sets that out very clearly.
Yeah, I agree.
So on that note, thank you very much for joining us today on this webinar. As stated earlier, a link to all the cases, the practice notes, the recording of the hearing itself, as well as the submissions from the FLBA. They were interveners in the case along with the ALC. All could be found on our website together with a case note. Thank you again for joining us. And do look out on our website for future webinars. And thank you, Gemma, for joining me.
Thank you, Rachel.